Welcome to the Kern County Employees Retirement Association August 24th, 2020 special meeting regarding the California Supreme Court Alameda decision. It is 13:02 hours. Amy, will you begin roll call, please?
Brandon?
Here.
Couch?
Here.
Dodgen?
Here.
Franey? Gonzalez?
Here.
Kaufman?
Here.
Kratt?
Here.
Nunnally?
Here.
Robinson?
Here.
Sibley?
Here.
Skidmore? Weitzel?
Here.
Thank you. We have a quorum.
Okay, we will have a brief moment of silence. Okay, returning back to the board, I will give a real quick overview of how this will run. We have several items on the agenda today, and I know we have quite a number of people that have called in and quite a number of people that are wanting to make comments. So we will open up the agenda item, we will have discussion from the board, and then I will open it up to public comments from the public. If you wish to make a comment and you're a member of the public, you can unmute yourself by pressing *6 and then immediately state your name, Bill Smith. And then I will proceed and say, you have the floor, Bill Smith. And you can make your public comment for 2 minutes. We'd like to keep all the comments under 2 minutes if we can, 2 minutes. We will have public comment on each item, whether it's the education or the ratification. And then we will also reconvene back at 3:30 from executive session. With that, I will begin with item number 1. Trustee education regarding the California Supreme Court decision in Alameda County Deputy Sheriff's Association versus Alameda County Employees Retirement Association, 2020 P3D WL 4360051 S247095 Alameda, presented by Fiduciary Counsel Ashley Dunning, partner, Nossaman LLP. Receive educational training, 45 minutes trustee education credit. I will turn it over to Ashley, Ms. Dunning. Ashley, would you also give a brief introduction of yourself?
I'd be happy to, and thank you, Mr. Chair, and thank you to the board of Casera for having me here today. Can you hear me all right?
Yes.
Yes, okay. My name is Ashley Dunning, and I am the co-chair of the Public Pensions and Investments Practice Group at Nossaman. I am fiduciary counsel to Casera, and my specialty is public pension law. I represent public retirement systems throughout California and the country on a variety of matters impacting them. I also have been involved in litigating the Alameda case that is the subject of our discussion today. Amy, will you be putting the slides on the screen so we can start, please?
Yes, I
Thank
will.
you. All right, thank you. I think this first slide simply says what I just encapsulated. So if we can go to slide 2, please. When I speak with the Casera board or any other public retirement board in California about fiduciary duties, as you know, we start with the California Constitution. We start with Article 16, Section 17 of the California Constitution, which vests your board with what's called plenary authority over the administration of the retirement system. That plenary authority is, of course, subject to your fiduciary duties of care and loyalty. One of the points that we always need to impress upon you in speaking about your fiduciary duties is that while you have this great authority and important responsibility, your exercise of that authority and of those responsibilities is always subject to judicial review. And the highest judicial authority in California, who rules on matters of California law, and in particular the statutes that govern you, is the California Supreme Court. On July 30th, 2020, the California Supreme Court filed its Alameda decision. This is a landmark decision that interprets the very statute that you administer, the County Employees Retirement Law of 1937. This is a 98-page opinion of a unanimous Supreme Court written by the Chief Justice. It is a very important decision. Now that Alameda has been decided by the highest court in California, and it interprets the law applicable to county retirement systems, CASERA is bound by its mandates. Alameda is important for a number of reasons, one of which is that it does describe the fiduciary and administrative role of public retirement boards to implement statutes that govern them as those statutes are written. Next slide, please. Slide 3. The specific statute that was primarily addressed in the Alameda decision is Government Code Section 31461 of Searle, as that statute was amended by Assembly Bill 197 and the Public Employees Pension Reform Act of 2013, commonly known as PEPRA. I will refer to these amendments as the PEPRA amendments, even though in the past we've often referred to the specific amendment in question here as the AB 197 amendment. This PEPRA amendment required new exclusions from the definition of compensation earnable that the Alameda court determined were, in large part, changes in law. That's very important to understand, that the Supreme Court determined that these changes were, or that these amendments were changes in law. The Supreme Court further determined, though, that these new exclusions were both constitutional, and therefore they did not violate people's vested rights, and that they must be applied, even if there were pre-existing settlement agreements or other retirement board actions that provided that certain pay items would be included in compensation earnable. And even if active members had paid retirement contributions on those pay items. Those were specific arguments that the court considered in terms of assessing the legality of the PEPRA amendments, and it determined that notwithstanding those arguments, the statute must be applied as written. Next slide, please. Slide 4. So what has happened at CASERA pending this litigation? When PEPRA was adopted, effective January 1st, 2013, the 20 county retirement systems were faced with a question of what to do. A number of those systems, including the 3 that were in litigation in the Alameda, in the case that resulted in the Alameda decision, changed the pensionability of pay items in response to PEPRA. They were sued. CASERA did not change a number of its pay codes. It saw that litigation had been filed. It determined that it had a post-Ventura settlement agreement that provided that some of these items were to be included. It considered other prior board actions and decided for the time being to wait and see what happened in the litigation. Next slide, please. The Alameda decision, as I mentioned at the outset, was filed July 30th, 2020. And pursuant to California Supreme Court rules, it's considered final 30 days after that date. In short, Alameda rejected the vested rights and estoppel-based concerns, including those that were based on post-Ventura settlement agreements that had dissuaded the CASERA board from acting on PEPRA previously, with respect to both your legacy and your PEPRA members. Next slide, please. It's important to realize, and when thinking about this case, that the court's conclusions were based on its analysis of some narrow questions relating to the legality of the specific PEPRA amendments that were in question and addressed in the case. And those were the amendments to the compensation earnable statute. And what the Supreme Court concluded was that because those amendments it deemed to be sufficiently consistent with the theory and successful operation of a public pension system, and because requiring comparable new advantages to members who were disadvantaged by those changes in law would undermine the constitutionally permitted purpose of the changes, that they were upheld as both a matter of law and equity. Next slide, please. So the question for Casera then becomes several-fold, and I identified 4 key questions. The first question is, to whom does Alameda apply? What group of your membership must have their benefits calculated in a manner that conforms to the mandates of Alameda? The second question is, now that we've identified the class of people to whom this covers, or the group of people, what period of time are these benefits to be corrected for? Is it prospective only, or does there need to be a look back? Third, what about member contributions? And then finally, what specific pay items are we talking about? What needs to be excluded? And I'll go through each of these 4 questions in the order I've presented them here. Next slide, please. Moving to slide 8. So turning to that first question, to whom does Alameda apply? I've quoted on this slide 8, I think, one of the many critically important statements of the Supreme Court in the decision. And that is, quote, county retirement boards have the ordinary authority of an administrative body to resolve, in the first instance, ambiguities in the interpretation and application of these statutes. But nothing in the text of sections 31460 and 31461 hints that the discretion extends further. In other words, as we've said before with respect to certain ambiguous statutes within the SURL, you're the first one who has to try and figure out what they mean. But to the extent that the statutes provide, for example, here, that an item is either compensation or not compensation, is compensation earnable or is not compensation earnable, retirement boards have no discretion to apply the law differently from what the statute provides. Next slide, please. There were some pretty important arguments made during the case to which the Supreme Court responds on this, as quoted on this slide 9. And I'll tell you what those arguments were so that you can fully understand the import of the Supreme Court statement here. One of the arguments that the plaintiffs in the case were making, and those were the unions and the individuals who were suing, was that retirement boards had the authority to have included certain pay items in the calculation of compensation earnable when they made those decisions, when they entered into their settlement agreements, for example, their post-Ventura settlement agreements, or when they adopted board resolutions before PEPRA, saying that certain pay codes were in. And the argument went, because they had the authority to exercise that discretion, once they'd exercised it that way, they did not have the authority to change that exercise of discretion. The counter argument that the state made, because the state of California intervened in the cases to defend the constitutionality of the statute, the argument that the state made was retirement boards did not have the discretion to include those items before. In fact, it was illegal. They should never have included those items in their calculation of compensation earnable before PEPRA, even before PEPRA. Well, the Supreme Court rejected both of those arguments. And they did so in part in this paragraph that I've quoted on slide 9. What they said was, quote, "We assume for purposes of this analysis that the settlement agreements embodied permissible interpretations of Searle at the time they were executed. The issue here is whether the retirement boards could have agreed to continue to implement those interpretations despite a statutory amendment that rendered the interpretations contrary to Searle. For the reasons discussed above, such a provision would have been beyond their authority. County employees can have no express contractual right to the continued adherence to interpretations of Searle that are now, as a result of PEPRA, contrary to the statute." So again, this is getting back to this very important message and ruling from the Supreme Court, which focuses on the limits on authority of retirement boards to include in compensation earnable that which the statute says may not be included. There are a couple of other aspects of this particular quote that I want to focus on for a minute before we get to the next slide. And that because it goes to the question of to whom Alameda applies. First of all, when the Supreme Court refers to county employees here, they refer to county in the same generic way that the Searle itself at sometimes refers to county, which is they're referring to your participating employers. So it's not just county employees, it's the employees of the courts or any other participating employers of Casera whose employees are subject to this statute. Secondly, when they say employees, they're referring to people who are employees at the time when PEPRA came into effect. That is, as of January 1st, 2013 following. So those employees may have retired since then, but when the Supreme Court says that the statute, the PEPRA needs to be applied to county employees, it's referring to those who had not yet retired from Casera as of the enactment of PEPRA. And that's a point that's made in other parts of the decision as well, that they have not yet retired. So deferred or active members who had not yet retired as of January 1st, 2013 are subject to PEPRA. Next slide, please. Slide 10 then answers this question, to whom does Alameda apply? Alameda thus determines that PEPRA's amendments to section 31461 apply effective January 1, 2013 as written. There's a theme that I've also stated in the second bullet point of slide 10 that we see in a number of different cases. It actually was in the Ventura case itself back in 1997, and then was repeated in the in-rate retirement cases, and also in the City versus SD Sears case. And that is that there's no basis under this circumstance to perpetuate the erroneous construction of Searle, as the Supreme Court concluded would occur if you do not apply the PEPRA amendments per Alameda, even as to currently retired members. The City versus SD Sears case is an important one because that's a case that deemed a retirement board's effort to give people a little more time to get the benefit of a provision in the municipal code than the board had determined should apply to this group initially. And I'll put a finer point on that. The board in that situation had determined that service credit was more costly than they had set the price previously. This is for service credit purchases. And so it set a new way for service credit purchases to be made, which ended up being more expensive for most of the members. but they created a window period and said, okay, well, if you come in within this 90-day period, you can purchase the service credit at the old rate. This is service credit that the city charter said was supposed to be cost neutral to the employer. So that the employee was supposed to be paying for the whole cost of the benefit. A lot of people came into the retirement system during that 90 days and purchased that service credit at the lower price. Many, many, many years later, decades later, the city sued the retirement system for having created that window period. And the Court of Appeal agreed with the city and said the board had no authority to have a window period. So you can't sort of artificially create a circumstance where members are getting benefits that they're not entitled to. Next slide, please. Thus, as to CASERA, Alameda's interpretation of the PEPRA amendments to section 31461, which I call the PEPRA exclusions, apply to CASERA's legacy members who retired and will retire on and after January 1st, 2013, because that was the statute-based law applicable to those individuals when they retired. A nuance here that's important for CASERA is that, as I noted at the outset, some of those exclusions that apply to under both the PEPRA amendments to the SERL, as well as to the new definition of compensation, of pensionable compensation that applies to PEPRA members, also were not implemented by CASERA, I think out of concern that it didn't comply with your post-Ventura settlement agreement. Well, now that we have Alameda, Alameda makes clear that that post-Ventura settlement agreement provides no basis for you to not follow the statute. So those statutes need to be applied as to all of your members. Next slide, please. And when I say all of your members, it's everyone who retires on and after January 1st, 2013. So now we go to question number 2, which is what period of time are retirement benefits to be corrected under Alameda? This is a different question from to whom it applies, because what it goes to is the payroll, the stream of benefits, and what if you've been making overpayments to your retirees since arguably 2013 as to people who retired in 2013. What do you do about that? Because now we're talking about 7 years of overpayments. First of all, basic principle, retirement benefits that CASERA pays to retirees on a go-forward basis need to implement PEPRA's amendments to the applicable statutes. So for legacy members, PEPRA's amendments to 31461, and for PEPRA members, we're talking specifically here about the exclusions in Subdivision C of section 7522.34. Your forward-looking stream of benefits to retirees need to be correct. A decision will need to be made by the board about any potential recoupment of overpayments from retirees with respect to the PEPRA exclusions. So that's something that the board will need to consider under both California law and federal law. And I note the federal law here in my third bullet point on slide 12, which is deferring to your tax counsel, who will need to address the federal tax qualification topic regarding permissible error correction. That's a mouthful, but basically what it means is that in order to remain a tax qualified plan, which allows your retirees to not, or your members to not pay taxes on their benefits until they actually draw them, and allows you to have your investment earnings not be taxed. So incredibly important. You have to do your corrections, error corrections in a particular way. So your tax counsel will advise you on that separately. Next slide, please. Question number 3 is, what about member contributions? There's a footnote in the Alameda decision, which is footnote number 18, in which the Supreme Court responds to another argument that the plaintiffs made, which was, we paid contributions on all of these pay items. Shouldn't we therefore get the benefit of them? And the Supreme Court said it would not address nor therefore decide that topic. They were not going to decide whether return of any member contributions made on pay items that were excluded by the PEPRA amendment was warranted. I have a few comments on that point. The first is that when you're talking about member contributions on pay codes associated with pay items from before January 1st, 2013, not only was Casera permitted to take those contributions, they were actually required by Searle. Well, PEPRA wasn't in effect yet, but they were actually required by Searle. And so the PEPRA amendments to Searle do not provide for a refund of contributions. And so we conclude that such a refund would not be warranted. And I contrast here the PEPRA amendments to the compensation earnable definition with the PEPRA amendments to the felony forfeiture rules, which was also part of PEPRA. And there, the legislature tightened up the context within which a person's retirement benefit can be forfeited from them because they commit a felony, typically either on the job or in trying to get benefits from the retirement system. And there, the new statute says if somebody's benefit is forfeited for those reasons, then they'll get a return of certain contributions that they made towards the forfeited benefit. In other words, the legislature knows how to call for a refund of contributions if that's what's intended. But in the case of this situation where we have additional pay codes that you're not allowed to include in compensation earnable after January 1st, 2013, there's no provision in Searle to refund those contributions. Next slide, please. Slide 14. A decision will need to be made about whether and how to return contributions to active and deferred members that were taken on excluded pay items from January 1st, 2013 forward, including addressing the topic as to retired members where they may have received an overpaid benefit that would offset the member contributions, presumably, that they paid on those excluded items. Next slide, please. Slide 15. So the question number 4, what pay items must be excluded from compensation earnable now? Alameda describes somewhat greater restraints on Searle boards than previously was understood with respect to inclusions in compensation earnable that statutes did not permit. And I've talked about some of those exclusions already. But there's one part of the decision that I think is important for you to also understand, and that is the discussion of Gelfi footnote 6. Gelfi was a Court of Appeal decision from the 80s, 89, that had a footnote in it that had come to be understood to suggest that while retirement boards were bound to include certain items in compensation earnable, that was just a floor. And they actually could include a lot more than that. So there wasn't, in other words, there wasn't a ceiling on what could be included in compensation earnable. The Supreme Court tackled that argument and flatly rejected it. They said that they disapproved of Gelfi footnote 6 and said if an item of pay is not compensation, it's not to be included in compensation earnable, and therefore boards may not include it. And I call those the Alameda exclusions. We haven't at the moment come across a specific Alameda exclusion for Casera, but I want you to be attuned to it because it's different from a PEPRA exclusion. Per the Supreme Court's discussion of Section 31461 as amended, PEPRA had some important rationale. And those rationale included to close certain loopholes in how retirement benefits are calculated. So for example, there's a discussion of using leave cash outs in a way that straddles fiscal or calendar years and results in people getting more than they would normally be permitted to receive in cash and earn within each 12-month period of their final compensation. That's a PEPRA exclusion. And it also eliminates the exclusion of in-kind benefits in compensation earnable. That would be a benefit that, say, you can only get in kind. It's a premium, healthcare premium, for example. Some systems have included that in retirement allowance calculations, and the Supreme Court said in-kind benefits such as that are not includable. That's a PEPRA, an Alameda exclusion. Next slide, please. The way to discern which pay items must be excluded from compensation earnable now is to focus on the statutory exclusions listed in the codes. And for legacy members, we have mandatory exclusions in subdivisions B2, 3, and 4. Those are the terminal pay, any leave cash outs in excess of what you can earn and receive in cash in each 12-month period, and additional payments for services rendered outside of normal working hours. That's B3. B1 describes another type of mandatory exclusion, which is if somebody's being paid an amount in order to enhance their retirement benefit, the retirement board actually has an obligation to exclude those amounts. It says it shall in no case include payments that are made to enhance a member's retirement benefit. But then it also identifies what types of payments may be excluded as a result of that statutory provision. And those are conversions to cash of in-kind benefits, one-time or ad hoc payments of benefits, and pre-termination golden handshakes. In other words, something that a member will receive as a condition or on condition that they retire, but they receive it before they retire. So arguably before it would not have been considered terminal pay. That's something that you can and probably should exclude now. Discretionary as opposed to mandatory PEPRA exclusions, though, we believe shouldn't be applied for the first time to people who are currently retired as a result of Alameda, unless you already took action in response to PEPRA to exclude those items. Next slide, please. So now on slide 17, what to do next? CASERA is to determine each pay code that is not to be included in compensation earnable under the PEPRA amendments and exclude those pay codes for purposes of both contribution collection and benefit payments for individuals who retired from CASERA on or after January 1st, 2013. And we recommend that you adopt a resolution implementing the Alameda decision so that you provide proper direction to CASERA staff on these topics. I believe that's it. Yes, thank you.
Okay. Ashley, thank you very much. Executive Director Dominic Brown, do you have any comments you want to make on this?
At this time, Mr. Chairman, I don't have any comments except to say that CASERA staff is digesting all of this information in real time and looking to make application at another point in the future. So the resolution that will be considered later in the agenda will get a little bit more into the specifics of this, but really not a lot of specifics yet. Right now, the focus is just the education, the court decision, the definition of terms, sort of the framework and the moving pieces in which your board and CASERA staff will look to understand this decision and then make implementation in the future.
Okay, thank you. General Counsel, do you have any, Jennifer Zara, do you have any comments you want to make?
No, I don't have any comments at this time.
Okay. I will open it up to the board. Any board members have any comments on the trustee education part? I see Trustee Gonzalez's hand. Trustee Gonzalez?
Yes, this message is for Ashley's, or question, not message. So I was kind of curious about, like, you said there was still some discretion left out in the Alameda decision. So I guess, I don't know if you could elaborate a little bit more about those discretions.
I think I missed your key word. You said there was something in the Alameda decision?
Yeah, like some discretions, like certain.
Oh,
Yes.
right. There are certain strict rules that you must apply under the Alameda decision in terms of exclusions that are listed in the SERL as B2, 3, and 4 of that statute. So 2 is leave cash outs beyond which you earn and can receive in cash every 12 months of your final comp period. That's a mandatory exclusion. Another mandatory exclusion is payment for additional services rendered outside of normal working hours. That's a mandatory exclusion. And then 4th, termination pay is a mandatory exclusion, unless the person could receive it in cash before termination in an amount that's limited by the same earned and payable every 12 month, each 12-month period of a final comp period. When I said there were some discretionary components, it's other types of payments. If somebody gets a one-time or an ad hoc payment, and it's not made to all similarly situated members in the class or grade, that's a context where your staff can flag it. You can go through a review process and determine whether it should be pulled out because it was paid to basically illegally inflate somebody's retirement benefit. Another discretionary one would be if somebody received what I call a golden handshake. So it was we'll pay you a lot of money if you leave, and we'll pay it to you before you leave, so it will be included in your final check or your second to last check, and it ends up increasing somebody's retirement benefit substantially. Staff can flag that and pull it out of the retirement allowance calculation as a way to not have that sort of artificial inflation of the retirement allowance occur. And also in terms of in-kind conversion, so somebody receives, say, a health benefit for their entire career, and then in the last year of their work, they convert it to cash and receive it in cash. That's the type of thing that also could be excluded by the board on a discretionary basis. Could decide we're not going to allow for those types of in-kind conversions as a way to, the rationale would be it's a form of gamesmanship that is contributions are taken on those amounts during a person's career when they get them in cash in kind. So then taking it in cash in the last period would be something that you may want to pull out. But that would be something you do on a go forward basis as to future retirees. Did that answer your question, Mr. Gonzalez?
Yes, it did. Thank you.
Okay, any other trustees have any questions? Trustee Robinson.
Hello. So can you clarify on whether or not a person taking terminal vacation in order to maybe like avoid taxation, which would potentially increase their pension contribution and service credit and push back their date, technically that sounds like that would be an in-kind conversion as well as a kind of like a termination benefit or something. So are we doing away with that altogether? Is that what it's specifying we need to do away with, or is that kind of out of it? Because I feel like that's basic, that I don't know, and maybe I'm misunderstanding.
And let me clarify, what we're talking about is what is or is not pensionable, not what can or cannot be paid for. Employers will be paying people out for unused leave as they're required to by law they will have their pay practices that they implement pursuant to the laws that apply to them. The question that matters for Casera and for the board is what is going to be included in people's retirement allowance calculation. For your PEPRA members, no leave is allowed to be included in retirement allowance calculations, period. That's an absolute prohibition. For your legacy members, what the statute says is terminal pay is not included if you can only get it on termination. But if you have, say, a sellback provision, like a vacation sellback where you can sell back up to 40 hours a year, you can earn, say, 100 hours and you can sell back, say, 40 hours, that's still allowed to be included in the calculation of people's retirement allowances on a go-forward basis for your legacy members. Does that answer the question, Trustee Robinson?
Somewhat, but by virtue of the service credit and the date that one's last date being changed based on when they took their terminal vacation or sick leave, all that, then it would impact the retirement. It would impact the date that they retire. So by virtue of that is what I'm asking, then would that now need to be adjusted?
So if people are running out their leave, so they're, if I'm understanding this correctly, the scenario you presented, if they are retiring on the date after they run out their vacation or sick leave, they're getting paid. It's just like any other vacation or sick leave that's paid. They pay contributions on it. It's included in their retirement calculation. They're getting their service credit. What we're talking about here in terms of cash outs is that they're not running it out. They're not, it's not the time. It's an additional cash, and it may not be a benefit that all employers allow their employees to cash out, to get cash in lieu of vacation. But yeah, if somebody's just running out their time and they're getting service credit and they're getting paid in the normal course, it's their 2 weeks or their month or whatever it is, that's all treated normally. There's no change to that.
Very good, thank you. Any other board member have any questions? Trustee Sibley.
Rick, this is for you. When we go into executive session, is Ashley going to be in there to answer some of these questions?
That's correct.
Thank you.
Any other board member have any questions on item 1? Okay. I will open up to public comment. Now, what I'd like to do is if you want to make a public comment, you press *6. You can unmute your phone and state your first name, Bill Smith. I'll reply, Bill Smith, you have the floor. And please keep your comments to 2 minutes. I will now open up to public comments on item 1, trustee education specific to the law. Do I have any public comments?
Ray Schill.
Okay, go ahead.
Yeah, the question is, if you've retired before January 2013, does that make you a legacy member, or does this not affect you at all?
Ashley, do you want to take that?
Sure. In terms of implementation of the Alameda decision and its upholding of PEPRA amendments, it would not impact people who retired before January 1st, 2013.
Great. So anything that's been said today will not affect anybody who retired before January 2013.
Right. If the retirement date was before January 1st, 2013, correct?
Okay, great. Thank you.
Thank you. Do I have any other public comments?
William Steiger, I have a question for Ashley.
William, go ahead.
I have a general question, then a specific follow-up. The general question is, has Casera come forward with a proposed list of the pay codes that they will believe will be excluded from the compensation calculable column? That's the first question.
That's what's being worked on, right, and would come forward at a later meeting, I believe. And I can defer to your general counsel if she'd like to add to that.
Do you want to make comment on that, Jennifer?
I can quickly just say that that's the information Casera's, as the executive director noted, we're gathering all this information, we're pulling it all together, and then the plan is to hopefully come back with that list for the board's consideration at the September meeting.
Okay, thank you. I have a brief follow-up for Ashley, and maybe she knows the answer to this. The pay code VB, which is the 24 hours of bonus vacation time paid to members who have maxed their sick leave at the end of, or at the last pay period of December, is that considered to be, or do you believe that that will be considered includable or excludable for legacy members, those who were hired before PEPRA, pre-PEPRA?
So that's the type of thing that we'll come back with for the September meeting.
Okay, so you don't have an opinion at this time?
Right.
Okay, thank you.
Thank you. Do I have any other member of the public who wants to make a comment?
William Little.
Mr. Little, go ahead.
Is the 3-year averaging only applying to new members after January 2013? And the second question is more for the board. Is the current comp earnable list published on the website the one that's going to be used, or is it going to change?
Go ahead, Jennifer.
I was gonna say, do you want me to answer, or are we?
Yeah, go ahead.
Okay, so the 3-year average is part of the PEPRA law, and that's been in existence for new members under PEPRA, everybody that became a new member of Casera after January 1, 2013, and that remains the law. The compensation earnable lists are published on our website. If you go to the Casera website and in the search tab, you type in compensation earnable, it'll come up. If you click on that, it is current as of our last board meeting, I believe, those pay codes that were approved then, but it does not have the ones we're considering now. Once we do consider those, it will be published on the website.
I couldn't understand the last thing you said. Once it's considered what?
Once the board makes a decision on those pay codes, the ones that we are considering right now, then we will.
Sean, Foxy.
Hey, we were talking over there. I'm sorry, Jennifer, go ahead. Your last part, I think, cut out.
It will be published on the website once the board makes the final determination on these pays that we are currently considering.
Okay. Yeah, for the public, that I'm sure a lot of them are calling in and wanting to know if a specific pay code is going to be deemed pensionable or unpensionable. We don't have a list of all the pay codes as of right now. We have a general idea of what pay codes are, but the board will formally adopt those at the September meeting. So if you have a question like, is my ZX pay code going to be pensionable or non-pensionable, we won't be able to answer that at this time. Okay, next public comment, please. Go ahead.
Tim Talbot. Sean.
There's too many of you. Tim, I heard a Tim. Tim, you have the floor.
Yes, thank you. It's Tim Talbot. I just had a question about process. So at the point that you adopt whatever resolutions you ultimately do adopt, notice to legacy retirees, those who retired after 2013, who are going to see reductions in their current pension benefits and potentially be exposed to recoupment. Are each of those retirees going to receive special or individualized notice showing the impact to them individually, such that they could at least comment or respond? Or have you gotten that far in terms of the process?
Jennifer, go ahead.
Mr. Chairman,
Probably a Dominic question.
Yeah, go ahead, Dominic.
Yeah, Mr. Chairman, for those that are on the phone, my name is Dominic Brown. I am the executive director. And yes, staff has every intention of making personal contact with each member before any of the potential impacts actually affect their paychecks or their pension payments in the future.
Thank you.
Okay. Next public comment, please. Any
Sean
more
DeFosse.
Sean, go ahead. You have the floor.
Yeah, thank you. I just wanted to get an idea of the time frame for the implementation. It sounds like September you're hoping to have some lists put together. Is that kind of the time frame and kind of getting this thing implemented?
Mr. Chairman, our next regularly scheduled board meeting is September 9th at 8:30 a.m. It is staff's goal to have much, if not all of this work done and ready to present to the board by then. However, that is quite ambitious. The trouble with the way that this decision came down is that we are now on the clock, and every pay period past that point in which the implementation is not made makes the problem worse and exposes our membership to additional future corrections.
Okay, next public comment. Okay. We got.
Greg.
Okay, go ahead, Mrs. Scribbs.
Does this include if you're buying back previous time, like military time, to add to your retirement time? Is that going to be affected?
Mr. Brown, do you have a comment on that?
I'm going to look to counsel on that one, or perhaps even staff. Every single one of these things will be analyzed according to the law, and if there is any impact to service purchases, or if that in any way affects the pricing of the purchase price, then that will be factored into the calculation.
As far as
okay, thank you.
Thank you.
With regard to military purchase time, that should not be affected. I can't think of any reason why that would be affected. Ashley,
right.
Any reason?
No. Okay, next public comment, please.
Daniel Seaborn.
Mr. Freeborn, go ahead.
Hi, that's Seaborn. I apologize. S-E-A-B-O-N. I have two. I was on call in a job that required, there were so few people there that there was no way to fill the shift without being on call, but it was required for the hospital. But it was prior to 2013. Would that be included or disincluded? And then when I retired, my wife had a major medical problem, and I had a ton of sick leave because I was never allowed to go anywhere or do anything because I had to be there to do my job. So are both of these going to be figured in or out? I mean, when you have no control over what's happening to you because you have a specific job title that you can't, nobody fills. They can't get anybody to fill it. And so you're stuck doing this overtime and you're stuck not being able to take the time off. How do you get penalized for that?
Mr. Chair, do you want me to?
Yeah, Ashley Dunning, would you take that, please? I'm not quite clear on, but maybe you can clear it up for him.
Go ahead.
So, the Supreme Court made clear that it doesn't assign any negative sentiment to the pay codes it was talking about. In terms of on-call or standby or even leave cash out. The issue is whether under the statutory amendments, those items are pensionable. And on-call is one of those types of pay that were just front and central in the litigation. That was the type of pay that was identified as additional pay for services rendered outside of normal working hours of individuals. So,
but if you look at the rule on there, it said if all individuals in that position do that, it was okay. And two, if it was necessary to continue to fill the position because it was required portion of the job, there had to be somebody there to do this 24 hours a day.
So okay? This will be something that the board, yeah, and I don't want to get into a back and forth if that's all right, but
Yeah.
the board will address it. I'm simply saying that the Supreme Court determined that the statutory exclusion is lawful and must be applied regardless of what the board did previously. And on-call is one of those types of pay. I'm not sure about the medical situation you described, but that could be addressed separately, perhaps through a sidebar.
Yeah, the on-call happened before 2013. It probably ended about 2010 because I slowly but surely got people trained and filled those positions so the on-call disappeared.
Yeah, and that's exactly,
But
that was exactly
that's before that's before the
yeah
2013 though. That's before the PEPRA, right? So it should affect it.
The concern expressed by the plaintiffs in the case was exactly the one that you're expressing, which is that this law applies to people who've already done the work. The Supreme Court said it is nonetheless legal. So for people who are retiring on and after PEPRA's enactment, it applies to them. Even though...
Or those people who made the decision not to follow it. Go ahead.
So even though it does apply to time periods where it was included at that time, the Supreme Court said it still needs to be followed.
So how do they solve this? Are they going to have a reduction in pay for everybody who had that problem that you have no control?
We're way past 2 minutes, and I appreciate your comment, but I have to move on. If you have if you have a specific question that applies to a certain particular situation that you were in or a pay code, again, we will not be able to answer that today. If you want to come and listen in on the September meeting and want to know a specific pay code, it is most likely that we will have those pay codes at the September meeting.
Okay.
All right. Thank you, sir. Next public comment, please. Any more public comments?
Bruce Bell.
Bruce, go ahead.
Not to belabor his issue, but anything prior to 2013, even if they had standby, that is not affected if they retire before 2013.
The bright line as we understand it is if you retired before January 1st, 2013, PEPRA doesn't apply to you. But if you retired after January, on or after January 1st, 2013, PEPRA does apply to you as to this topic.
Okay. Thank you.
Thank you for your comments. Any other public comments?
Phyllis Nance.
I believe you said Philip. Is that correct?
Phyllis.
Yes, go ahead.
So I'm looking, and so this may be going to come later. I'm looking at your agenda, and part of the agenda was the resolution. And when I look at the resolution, it indicates that the resolution says effective with the first retiree payroll occurring after Alameda is final as of August 31st. So is that in conflict, or am I just confused?
Phyllis, actually, we haven't even got to the resolution yet. We're still on item number 1, trustee education regarding the education specific to the law. If you want to comment on the resolution, I would suggest when we get to item number 3, we can discuss that.
I think what I was trying to understand is that you were going to do the pay codes in September, but the resolution sounded like it was already decided what the exclusions were going to be. So I can wait for that discussion, but that was what I was talking about, seemed to be in conflict.
Mr. Brown, do you have a comment on that?
Mr. Chairman, the one comment that I will offer, and I would ask Ms. Dunning to check me on this. So the timing here is extremely important all the way around. And it's my understanding that because the law changed effective January 1st, 2013, if somebody has availability on call or standby up through 2012, it does not matter if they retire in 2013 14, 15, 16, etc., we will go back and find their highest final average compensation at the point in their career in which it was the highest, and we will use that as the basis of the calculation of their pension. So with regard to the question that was just asked, what we are looking to do is to implement as quickly as we can according to the law. Because of what I described a few minutes ago, we are now on the clock, and if we do not make these changes in accordance with the law, we are not only not in compliance with the law, but we're actually making the problem worse and exposing our membership to potential additional incorrect payments that will then have to be corrected.
Does that answer your question?
I think so.
Okay. And feel free to, if you want to comment on the resolution when we get to number 3, feel free to comment on that. Any more public comments?
Susan Wells.
Mrs. Wells, go ahead.
Thank you. I'm a little confused after Phyllis's question and the answer. So I understand, Dominic, that time is of the essence. I get that. But the resolution does say, as of the August 31st, 2020 retiree payroll. So I'm just wondering, when you look at the revised pay codes in September, they will have already been in effect. Is that what you're saying?
The one thing I'll say in response to that, we are consulting with not only fiduciary counsel, Ashley Dunning, but also tax counsel. Based on the inquiries that we've already begun, there's a possibility that we'll have to pick up one day of adjustment, the very last day of August, and make an adjustment in the September payroll, but we do not know that for sure yet. We're looking at it. General Counsel, do you have any further comment on that?
Well, again, this pertains more to item 3, but as
okay.
Nossaman Council noted about the window period and the case with regard to the window period, that date reflects a timing such that there won't be a window period. So again, we're going to consult with tax counsel and fiduciary counsel to find out what kind of corrections we need to make. But at a minimum, it appears, and again, I don't want to get ahead of the board, but
okay,
minimum we would probably at least need to correct for August. We will start the goal
okay.
To start, but we will need to correct for August at a minimum, it appears at this time.
Okay, I will wait for item 3 then and for further discussion.
Thank you, Susan.
Thank you.
Any other
Thanks.
public comments? Okay, one last shot. Any public comments?
William Little.
I'm sorry, state your name again, sir.
It's William Little again. I don't think I used 2 minutes last time anyways. I only have a very simple question. The labor association is going to be consulted with any items that are going to be changed from earnable to not earnable.
All right. You broke up. Can you repeat your question? I'm sorry. Can you repeat that one more time?
Sure. Are the affected labor organizations going to be consulted on the items that will be changed from earnable to not earnable?
Mr. Brown, do you have a comment on that?
Yes, Mr. Little and Mr. Chairman. So some of those conversations have already begun. I have personally spoken on the telephone with union leadership from what we believe at this point to be every affected union, and those conversations will be ongoing as we look to implement this law.
Thank you.
Thank you. Any other public comments? Okay. Hearing none, I'll wait like 3-4 more seconds. I will move on to public comment on executive session item number 2. Okay, one last time. Any public comments on item 1? All right, we are moving on. I am now on public comment for executive session item 2, conference of legal counsel. Anticipated litigation, significant exposure to litigation pursuant to paragraph 2 of subdivision D of section 54956.9 based on facts and circumstances that might result in litigation against Sarah and that Sarah believes are known to a potential plaintiff, which facts and circumstances shall be publicly announced prior to the closed session. California Government Section Code 54956.9E2. Number of potential cases numerous, specific number unknown at this time. Is there anyone who would like to make a public comment on item number 2? Okay, hearing none, we will move to executive session and we will reconvene at 3:30 p.m.
Mr. Chair, just a reminder to any of the callers, you can use the same meeting ID and phone numbers that are listed on the agenda to join the meeting again at 3:30.
For those that want to circle back at 3:30, if you didn't catch that, you can use the same meeting link. All right, we will adjourn to executive session. All right, welcome back. We are reconvening from executive session. This is the Kern County Employees Retirement Association special meeting on the Alameda, California Supreme Court case, August 24, 2020, 15:31 hours. Amy, we'll do roll call again.
Brandon?
Here.
Couch? Dodgen?
Here.
Franey? Gonzalez?
Here.
Kaufman? Kratt?
Here.
Nunley?
Here.
Robinson?
Here.
Sibley?
Here.
Skidmore? Weitzel?
Here.
Thank you. We have a quorum.
Okay. Reporting back from executive session. Item number 2, Conference of Legal Counsel, anticipated litigation, significant exposure to litigation pursuant to paragraph 2 of subsection D of section 54956.9 based on facts and circumstances that might result in litigation against Sarah and that Sarah believes are known to a potential plaintiff, which facts and circumstances shall be publicly announced prior to the closed session. California Government Section Code 54956.9E2. Number of potential cases numerous, specific number unknown at this time. The board has no reportable action. Amy?
I just wanted to read into the record, Mr. Chair, that Trustee Couch is here.
Okay, I believe also Trustee Skidmore's here now too.
Thank you.
So item number 2, the board has no reportable action. Moving on, we'll move to item number 3, discussion and appropriate action on resolution 2020-01, approve resolution setting forth directions to staff and actions needed to implement the Alameda decision. Mr. Brown?
Yes, thank you, Mr. Chairman. So I do have a cover memo here. I will briefly outline the purpose for our meeting today. The purpose for our meeting today is to consider the resolution that is before you. We brought a resolution before you because the PEPRA legislation was generated litigation against some of the systems that implemented that the California Supreme Court has now decided. And so Sarah is obligated to implement the Supreme Court's decision to our retirement system, Sarah. So that has brought us to where we are today. The California Supreme Court has determined that the PEPRA legislation was lawful, and so now we are required to implement it. So Ashley Dunning, our fiduciary counsel, and our general counsel have worked together to draft a resolution, which is now for consideration for your board. So I'll turn it over to Ashley to walk through the actual resolution itself.
Thank you very much, Mr. Brown, and I'll start with the resolution, just sort of summarizing the first provisions of it under the whereases. We have section 1, whereas, and subdivision A defines the terms of the people we're talking about here. So we have our legacy members who are subject to the compensation earnable definitions, and PEPRA members who are subject to the pensionable compensation definitions. Subparagraph B then describes the resolutions that the board previously adopted that were based in part on your own post-Ventura settlement agreement. Paragraph C then describes the Alameda decision that I walked through in some detail during the education portion of this, and described the Supreme Court's conclusions relating to the constitutionality of the PEPRA changes and the fact that PEPRA therefore needs to be applied notwithstanding any prior board actions applicable to people who retired on or after the PEPRA exclusions were enacted. Subdivision D refers to the topic that I discussed when describing Delphi footnote 6 and references the Alameda exclusions. And these are those exclusions that the Supreme Court said apply under the statute as it's always existed. And as a consequence, items that are not compensation under Searle may not be included in compensation earnable, and disapproving statements that have been interpreted to the contrary in other cases. And then E finally states that the board hereby determines that the Alameda decision and other applicable law require it to change its determination of certain pay codes for either compensation earnable, pensionable compensation, or both, as resolved below. And then actually finally, F relates to compliance with the Internal Revenue Code and federal tax qualification rules that I referenced earlier. So now we get to the next page of this resolution, which has the 1 through 7 resolved provisions. And why don't I go through each of these, and if board members want to stop me on any of them to talk about specific ones, we can do that, or I can go all the way through and then you can ask questions afterwards or make comments. Paragraph 1 simply says, comply with Alameda's directives regarding mandatorily excluded pay items, which includes the PEPRA exclusions, and apply that directive to all retiree payroll for individuals who retire on or after January 1st, 2013, including those who will retire on and after the date of this resolution, effective with the first retiree payroll occurring after Alameda is final. That is, as of the August 31, 2020 retiree payroll. I'll make a little parenthetical there just to acknowledge there were some questions earlier about implementation date and pay codes and that sort of thing. The recognition is that it will take a little time to actually implement this, but when it's implemented, it would be implemented as of August 31st 2020 retiree payroll pursuant to this resolution. Paragraph 2, comply with Alameda's directives regarding the board's lack of authority to include the Alameda exclusions in compensation earnable and pensionable compensation as applicable, and apply that directive to all retiree payroll for individuals who retire on or after July 30th, 2020, when the Supreme Court overturned Delphi footnote 6, and Casera was thus on notice of that statement of law, including those who will retire on or after the date of this resolution.
Ashley, Trustee Robinson has a question.
Yes, Trustee Robinson.
So just for clarity, the items that it's saying in item 1 and 2 that our board needs to comply with would be adjusting availability pay, standby pay, on call, bomb detail, board meeting minutes, and higher class, looks like higher class OT. That's the ones that I read were the definites, right?
The first ones that you mentioned there are the types of pay that would be excluded as a PEPRA exclusion. So paragraph 1. I don't believe any of the ones you recited were Alameda exclusions, but Jennifer, correct me if I'm wrong.
I think that's correct. Those were all PEPRA exclusions, keeping in mind that staff is still looking through and there could be others added to the list, but those are the group that we can identify will be excluded at this point.
And that's the pensionable comp, right? The ones that were on the list in the presentation, the pensionable comp, correct?
Well, it's compensation earnable for legacy members, pensionable compensation for PEPRA members.
For new members, right. So we're talking about, point one is referring to the PEPRA exclusions, which I went over, correct?
Right.
And point two, that's all talking about the I guess how do we refer?
The primary, a primary example would be premiums. So if you have a participating employer who provides a healthcare benefit, say a flex benefit, where the employee has no ability to get that payment in cash, but only receives the in-kind benefit of having a healthcare program provided to them. That type of payments in kind, it's under an Alameda exclusion, it's not to be included at all. But that would be the one that would apply to people who retire on or after the date that the Supreme Court overturned Gelfi's footnote 6, which is the July 30th date. Yeah.
And so is that the one that our board needs to determine if it's going to be, if we're going to move that to August 31st or July 30th? Like, is that the section that I need to understand right there?
So our recommendation is that the board apply the Supreme Court decision with respect to the Alameda exclusion as of the date when you were first on notice of that change in judicial precedent on that topic. So that's July 30th, 2020. Our recommendation as to what we believe is reasonable in terms of implementing the PEPRA exclusions relates to when your retiree payroll goes out. And so we focused on the first retiree payroll after Alameda became final. That one, you're already applying it to people who retired on and after January 1st, 2013. So it applies to a much larger group of people. But as to a retiree payroll that occurs on and after August 31st, 2020, the Alameda exclusions apply to a much smaller group of people in the sense that it doesn't apply to anyone who retired before July 30th, 2020. But it may apply, I don't know the numbers exactly, but it applies, it would apply on a go forward basis from July 30th, 2020 forward. And that's our recommendation. Okay, thank you. Paragraph 3 relates to the active member contribution topic. So this paragraph calls for information to be gathered by staff. And it says, determine all active member contributions that were erroneously taken on and after January 1st, 2013 on PEPRA exclusions, and any that were potentially erroneously taken on Alameda exclusions, and propose a methodology to address those errors in a manner that complies with applicable federal tax compliance rules and California law. So this provision isn't yet making a determination about exactly how to address those errors, but it is calling for the information to be gathered within the parameters set forth in this paragraph. Paragraph 4 deals with overpayments that occurred prior to the August 31, 2020 payroll to your current retirees. And this provision calls for invoking the system-wide error correction provisions of your existing error corrections policy. And that affords you a little more latitude in terms of how you address system-wide errors within Casera. And again, that would come back to you with further recommendations upon further consultation with council. Number 5, present revised pay codes as soon as practicable to the board to ratify exclusions from compensation earnable and pensionable compensation in compliance with Alameda, and communicate to Casera participating employers that member contributions are no longer to be taken on such pay codes. Again, this is something that your staff is already working on vigorously and hopes to bring back to you in September. And then there's the communication piece. Number 6 is also based on, or provides communication and inform Casera members of the foregoing actions through appropriate means, which will be both generalized communications and very specific ones to individuals. And then finally, number 7, this resolution supersedes any previous resolutions for employer pay codes of employee compensation. That's it. I'm happy to respond to any questions or if any board members have comments, now would be a good time.
Any board members have any comments? Trustee Gonzalez.
Yeah, so from my understanding of this resolution, there's still some details kind of missing as far as the exact codes and as far as, what exactly some of the fixes are going to be for our system. But this is really just painting a bigger picture of this is the direction we need to head to. This is we know we have to do these certain actions. We don't know exactly the exact detail of certain things, but we know we're going to go in this direction. So that's what I kind of feel about with this resolution. And so definitely seems like something we need to pass through so we can make sure that the staff have the right direction of where we need to go.
Thank you, Trustee Gonzalez. Any other board member have any questions or comments? Trustee Robinson.
Yes, I'd like to make a referral to staff on the Casera special pay allowance policy. If you could review it and see if specifically section 2 requires any update on background. I think it would just be consistent. And maybe a referral to admin committee as well.
Okay. Good with that, Dominic?
Yes, Mr. Chairman, I'm looking to council. Council, do we need anything further? Or I understand that to mean staff will take a look at it. If there's any changes to be proposed, we'll probably bring those straight to the admin committee for consideration.
Okay. Any other board member have any questions? Okay, I will open up to public comment now. Like what I did before, if you want to make a public comment, you push *6. Say your first and last name, Bill Smith. I'll recognize you, Bill Smith. You have the floor, and then we need to keep our comments in 2 minutes or less. And it needs to be a comment. If it's a specific question regarding like a pay code, then we're not going to be able to have like a list of pay codes today. And I know that's probably what everybody is interested in, but we will have in September at the September 9th board meeting, we should have each individual pay code and how it's going to be affected. All right, I'll open up to public comments. Is there any member of the public that would like to make a comment on item 3, the resolution?
Susan Wells.
Okay, Susan, go ahead.
I have a question. Your over/under payment policy. Is that something that is on your website that we can look at and read? I'm not familiar with that policy, and I know that if you're going to apply it, I'd like to see what it, the mechanics of it. And then I had another.
Go ahead, Susan.
Oh, I had another comment after that.
Okay.
Shall I make it now?
Jennifer, do you want to answer that?
I don't know offhand. I don't think so. I don't think it's on the website, but
can we post it? Can we get it posted tonight?
the board policy that's been approved by the board, so we can post that and make that available to the public.
Okay. Susan, you had another question?
Okay, thank you. I did. I just wondered if you could elaborate a little more on the treatment, the tax treatment on the status of employee contributions. I'm not sure. I've heard a lot of discussion about that today, but I'm not sure what that means. You know, the contributions that were taken on excluded pay code items, how does that exactly work with the tax status of the plan?
Jennifer?
So I think when Fiduciary Council was referring to the tax items, we're talking about consulting with tax counsel about what the IRS will require in terms of correction. I know generically the IRS says you need to make full corrections, but they are cognizant of California law, and so there's coordination we need between tax counsel and fiduciary counsel to figure out what we need to do. So that was the discussion with regard to taxes, and the reason we comply with what the IRS needs us to do is to maintain our tax qualified status, which is what enables actives to not have their contributions being taxed, our retirement, our investment returns not be taxed. So that was the discussion there. A different discussion that you might be talking about, which I don't think we raised in the education part, would be if we have to make corrections and if we have to refund, that would probably be more relevant to the active employees. If we had to refund their paid contributions, what would be the tax implications of that, right? Because they were
right
pre-tax basis, and if they never should have been concluded and we give them back, that's something we will definitely make clear to members in our future correspondence.
So if a retiree, if a current retiree made contributions based on a pay code that was erroneously included, then now fast forward to today, was included and shouldn't have been, is there any liability for that? And perhaps you don't know the answer to that question. Perhaps that's not a question for you, but I'm just wondering if there's any tax liability for that retiree.
Right, that's something we would definitely want to consult with tax counsel on, whether that's a true, if those corrections had to be made, and if they were to be offset against contributions that retirees previously made, could it just be a straight offset? Are there tax implications? Do they have to pay? All of that stuff, we are working through that, and we will make sure that gets known to affected members.
Okay, and will that be included? Will that discussion or answer or analysis be included on your September agenda?
We are planning to have tax counsel assist us. So hopefully he can be as comprehensive as possible with regard to.
Okay, thank you.
Thank you, Susan.
Thank you.
Do I have any other members of the public who want to make a comment on the resolution?
Tim Talbot.
Tim, go ahead.
Tim Talbot. Yeah, I just, in terms of your review of the pay codes between now and September, will there be an opportunity for input from the employee groups or some process that ensures you're not just looking at a title of a pay item and excluding the actual duties or the circumstances surrounding that particular item before you make a final decision?
Mr. Chairman, I'll respond to that one. This is Dominic Brown, Executive Director, and the answer to that question is yes. We will be not only taking the nominal name of the code, but also looking at the employment practice. And so we'll be consulting both with plan sponsors and with labor groups to make sure we understand not only what that code's name is, but how it is being used in order for us to make accurate determinations and recommendations to the board.
So that will include both the employing agency or department and the labor groups, particularly if it's under a collective bargaining agreement.
That is our goal. Yes, that is our goal, is to make initial determinations and then also solicit input to make sure that we do have it correct.
Okay, and how would we, what should we be looking for from your agency as to that solicitation? Will that be a formal request, informal through the KLEA president or whomever, so we don't miss the
Yeah,
opportunity?
like many things, we are making this up as we go. This is a bit unprecedented. So I will make sure that we make contact and make sure that we talk to the right person.
Okay, appreciate that. Thank you.
Tim, that September 9th meeting is probably a really important meeting, maybe even more important than this meeting. So, you know, that'll be a good meeting that you'll want to attend.
Thank you.
Okay, thank you. Any other member of the public would like to make a public comment? One last time, any member of the public would like to make a public comment on item number 3? All right, hearing none, we'll return it back to the board. Anyone want to make a motion or any further discussion from the board?
Mr. Chairman, Trustee Couch.
Sorry, my apologies. Trustee Couch, go ahead.
No problem. I'll make a motion to approve it, but I want to know if we could make, or better said, I would like to know if we have the discretion. This may not impact anyone, but if we do have a situation where we have a large refund, are we assuming that as soon as we get these things done, we're going to be sending out checks to people right here towards the end of the year?
Trustee Couch, I do not know for sure if we will be issuing checks. We will need to consult with tax counsel to figure out the legal and most appropriate way to administer according to the IRS.
Assuming you can't roll it over, assuming that's not an option. We'll just be, in that case, we would be issuing people checks, refund checks, right? Am I right?
Probably, yes.
Okay, if that, let's say it this way, if that's the case, do we have the discretion to offer people a multiple years of spreading that over time in case it was a large amount that they weren't planning for right at the end of the tax year?
That's a good question for tax counsel, and we'll have to take that into consideration as we move forward.
Thank you.
Okay.
That's a motion, by the way, to approve the resolution.
Motion by Trustee Couch to approve staff's recommendation. Trustee Robinson, you had your hand up.
I want to be clear about, is that motion to approve the resolution effective on the July or the August, as we discussed previously? I know that recommendation from council, but are we accepting fiduciary counsel's recommendation, or?
I was accepting that recommendation, but I'm open to discussion about changing that. I don't have a hard opinion about that.
Okay.
I agree with you in that I don't think a lot of people are going to rush down and retire in the next week.
Right.
Okay. Well, you know, if I could, and I mean, I don't know, I guess I'll wait for board input on that. How's everyone feeling about that?
Staff have a hard opinion or any issue over making it August 31st?
Yeah, I'll ask Ashley to comment again, but Ashley has specifically advised against that course of action because of a previous court case that had that exact circumstance. Ashley, do you have any further comment on that?
Yeah, we've been very specific about the dates that we recommend you apply this as of. So there's the August 31st payroll for the PEPRA exclusions, and there's the July 30th, 2020 for the Alameda exclusions. And while one may not expect that there will be a run for the exit, that does happen, and it has happened in other places where there's a big consequence to your retirement benefit of the date that you choose, and the very sort of directives that the Supreme Court gave retirement boards about the limitations on their authority, I think apply here. that the board, whether somebody has an item included in their retirement allowance or not, in this case, should not depend upon the date that the retirement board takes action. Which is why I think the best date is July 30th. That's the most reasonable date to deem the Supreme Court to have given you the directive about what you're not allowed to include in compensation earnable.
Well, since we went into closed session over potential litigation, I'm going to follow the attorney's advice and not add to the potential litigation.
Okay.
I'll second that.
I'm sorry, who seconded it?
Oh, Tyler Weitzel.
Okay, Trustee Weitzel, and then I have Trustee Robinson's hand back up. Trustee Robinson.
Yes, Ms. Dunning, I'm just, my question is, the July date, I mean, by deliberately backdating it to the date that the decision was made, we actually are attempting to impact the outcome. I mean, I just feel like we're legitimately trying to impact it, whereas we're having this meeting on the 24th, and the end of the month just seems appropriate. I mean, I see no other way than moving forward rather than, going out of our way, making effort to ensure that no one can, when this decision just came down the pipeline.
So let me put it this way. The Supreme Court is the ultimate arbiter, the ultimate judge who decides what the law is that applies to Casera. It's not this board. And so that's what applying the July 30th date does. It defers to the Supreme Court on matters that are within their authority.
But then we still have the discretion to move it one way or the other. So it's obviously not a must. It's a should. It should language, right?
On this point, I think that you've done as much as you can for your members by applying the decision as of the date it was issued on the Alameda exclusions. Because you've essentially been including in retirement allowances amounts that the SERL says you're not to include. And the Supreme Court has told you that as of July 30th, and you're applying it as of July 30th to people who retire on and after that date as to the Alameda exclusions. So I would say you're not creating a window period, you're closing a window period. You're not allowing for there to be a window period once you were on notice of this law.
Trustee Robbins, or Trustee Ramos. Trustee Gonzalez. Thank you. Sorry.
Yeah, no, it's okay. So, yeah, I think with regards to like the, even the August 31st date, the reason I think it's really important to have it there and not move any of those dates either is really because it's still going to affect them either way. Whether we choose August 31st, if we choose, October, November, we still have to choose whatever date we pick and then go back all the way to 2013 to make it anyways. So I think the sooner we're able to implement as practicable, right? As long as we have all the pay codes, we've done all the math and it seems to be correct. I think the soonest that we can get that in, the less complications there will be, the less disappointments to our members, like do retire between now and, whenever this date goes into effect. So yeah, so I think the sooner we can on August 31st, the pepper exclusions, I think the better.
Any other board member I can make a comment? We have a motion and a second. Trustee Robinson.
So what's the worst case scenario? Can you kind of explain it? So we do this thing August 31st. I mean, and is it just pandemonium and fires coming from the sky for our board now, or should we go with the? Can you kind of break it down?
Sure, and I'll break it down with the example that is a public one, and that is in the San Diego City Employees Retirement System situation. That board thought they were doing the right thing by creating a window period. And I'm going to get my dates wrong, but it was sometime in the 90s, I believe. And I mentioned this about the service credit purchases. It wasn't until much later that an assessment was made about the amount of money that had been lost as a result of that, that window period. And the city, for its own reasons at the time, the plan sponsor decided it wasn't gonna put up with that. And it sued the retirement system. So the retirement system then, after the Court of Appeal said you didn't have the authority to create that window period, made them go all the way back and do a correction for decades, what had happened decades before. So then you're dealing with having to unwind people's retirement benefits long after this had occurred. Right now, we're still talking about something that's very recent. And my recommendation is understanding that you know, this is complicated and you're having to make judgment calls. That is absolutely a given that you're making judgment calls. But in my judgment, the way to best avoid that problem is to apply it in the way we've recommended. You apply the Alameda exclusions as soon as you're aware of it as to people who retire on and after that date. And you apply the PEPR exclusions as soon as practicable to the next payroll after that decision, which is your August 31st payroll. We understand you can't get it implemented. Obviously, you can't get it implemented right away, which means that if it's implemented in November or December, it's an as-of date. So you're going to have to make corrections. You can't perpetuate the erroneous construction of the statute. That's what the Supreme Court has said. And by continuing to pay people retirement benefits, that is a perpetuation of the erroneous construction of the statutes. That's exactly what you're doing. So what we're trying to do is protect the integrity of the retirement system in the best way that you can by using dates that are based in the theory and successful operation of the plan, that are based in the guidance that the Supreme Court has given you and the directives that it's given you about what you have authority over and what you do not have authority over, and to give your staff set dates and guidelines and bright lines to follow. So that's what this resolution does. And I mean, I can think of all sorts of worst case scenarios. I'm not sure that this is the time, place, or circumstance where I should be articulating all of those. But I can tell you I've seen lawsuits from every single angle. And this is an attempt to prudently walk those lines in a way that has you keeping the ship afloat and doing the best by your members that you can under the circumstances, which admittedly are very difficult circumstances.
Okay, so I have a motion on the table and I have a second on staff's recommendation. Any further discussion? Trustee Robinson.
Wouldn't it be more appropriate to take this vote after at the September meeting after we get this IRS attorney guidance as well, or IRS counsel guidance as well? Don't you think?
Well, go ahead.
Yeah, the topics that are deferred in your resolution now are the ones that the tax council will be best suited to inform you about. For example, on the question of, do you need to recoup from your retirees? Do you need to get money back from them? I have a view about what California law provides and permits and the discretion it affords you. Tax council has their views about what is appropriate as well. Those are matters on which you should be fully informed by both both sets of laws before you act, but you're not dealing with that right now. All you're doing in this resolution is saying to your staff, we, as the governing body of CASERA, are directing you to follow Alameda. And here is how we expect you to do it in broad strokes.
Okay. Unless there's any further discussion, we will vote on this. And I see none. So Amy, let's do it.
Mr. Chair, also for the record, I just wanted to state that Trustee Kaufman had to leave during executive session, so alternate Trustee Nunley will be voting in his place. We'll take a roll call vote, please. Couch,
Yes.
Dodgen,
Yes.
Gonzalez,
Yes.
Kratt,
Yes.
Robinson,
No.
Skidmore,
Yes.
Weitzel,
Yes.
Nunley,
Yes.
Sibley.
Yes.
8 ayes, 1 no. Trustee Robinson, motion passed. Thank you.
Okay. Moving on. Item number 4, public comments. The public is provided the opportunity to comment on agenda items at the time those agenda items are discussed by the board. This portion of the meeting is reserved for persons to address the board on any matter not on this agenda, but under the jurisdiction of the board. Board members may respond briefly to statements made or questions posed. They may ask a question for clarification and through the chair make a referral to staff for factual information or request staff to report back to the board at a later meeting. Speakers are limited to 2 minutes. Please state your name for the record prior to making a presentation. Is there any member of the public that would like to make a public comment on an item not on this agenda? One more time. Any member of the public?
Bell.
Mr. Bell, you have a public comment?
This has nothing to do with this discussion, but it only has to do with the retirement. When you guys went through and voted to average the year, first of all, is this appropriate to even comment in this session, or is this better to be discussed?
If it's a comment, sure, we can take it. If it's a question, it's probably not. But
well,
go ahead.
in the form of a comment, it would be when it was decided that they would average and average each year's COLA to the nearest 0.5%, you guys left some in the unresolved. A lot of people have a 0.4, 0.3, 0.2, and 0.1 left over in the
COLA bank?
The COLA bank, thank you.
Yeah.
And I wasn't sure if that was ever going to be resolved where you guys would then average that to the nearest 0.5%, meaning that 0.2s and 0.1s would then be averaged out and 0.3 and 0.4 would then become a 0.5. And whether or not that was ever going to be part of the agenda, just to clear up the final little bit of mess that was left from that decision.
Do you have anything on that? Yeah, okay, thank you, Mr. Bell. Do you have anything on that, Dominic?
No, Mr. Chairman, that I believe is the first I've ever heard of that issue. I'm looking at General Counsel to see if she's ever heard of that issue. Probably predates me. I don't know.
I don't recall if it's this specific issue, but I remember Trustee DeMario, when he was on this board, he had brought an issue with regard to calculation of the COLA, and we had dug into the COLA at that point, and we had made corrections at that time. So I don't know if they were resolved at that point, or if there was something else that I don't recall anything that remained unresolved, but we can look into it.
Yeah, could you look into Dominic and get with Mr. Bell and take care of his question?
Sure, no problem.
Okay. Will that help you? Will that suffice, Mr. Bell?
Sure. Do you have contact information, I'm assuming?
I'm sure we do. Can you repeat your first and last name for the record?
Bruce, B-R-U-C-E, Bell, B-E-L-L.
Okay, very good. I'm sure we can find you.
Thank you, Mr. Bell.
Thank you very much.
Thank you, Mr. Bell. Any further comments on public comments not on this agenda? Okay, hearing none. Item 5, board member announcements report. On their own, board members may make a brief announcement or brief report on their own activities. Any board member have an announcement or report? Okay, seeing none. Item 6, this meeting is adjourned.
Mr. Chair.
Sorry.
Trustee Robinson has his hand up.
Trustee Robinson, we have a board member announcement or report.
Yes, I would just like to thank everyone for coming and tuning in, showing your diligence and support. Thank you to all the KSARA staff. I just want to thank you all for all your hard work and diligence given during this time.
Thank you, Trustee Robinson. Any other board member have any announcements or reports? Okay, now we're at item 6. Meeting is adjourned. Thank you, everyone.